Well, welcome back, folks, to another episode of American Genesis, where we're discussing the three important documents that form our national government. We've talked about the Declaration of Independence. I'm hopefully going to get done with the Constitution Day, and then we're going to proceed on to the Bill of Rights, which I think you'll really find interesting. I know it's my favorite part of the government to discuss. So, as we get started, let's listen to a little music, as always.
If tomorrow all the things were lost I'd worked for all my life, and I had to start again with just my children and my wife, I'd thank my lucky stars to be living here today, 'cause the flag still stands for freedom and they can't take that away. And I'm proud to be an American, where at least I know I'm free. And I won't forget the men who died and gave that right to me. And I'd gladly stand up next to you and defend her still today. 'Cause there ain't no doubt I love this land. God bless the USA.
Okay, well, let's review what we talked about last week. Last week, we looked at how the Supreme Court is organized and how past attempts to pack the court have failed. We then looked at the jurisdiction of the Supreme Court, noting that the Supreme Court is the only court which really still has both original and appellate jurisdiction. In other words, it can hear cases that no one else can hear, as well as hear cases on appeal from lower courts. We then looked at the three methods by which a case can be brought before the Supreme Court. We looked at the writ of certificate, which is where the court is asked to rule on something that is unique, different, maybe never been before the court before. For instance, I mentioned there was a court case about the sound waves when radio first came out. Who owned the sound waves, the airwaves? About 10% of the cases will reach the Supreme Court on appeal. That is, they ask the court, they appeal it, the case on its basically to see if there had been an error in the court earlier. And then there's what's called the writ of certiorari, usually called the writ of cert, which by far and away makes up the majority of cases. And basically, the plaintiff is asking the court to review the findings of a lower court to see if indeed they were correct. Then we went into detail, quite a bit of detail, spent a lot of time on the operation of the Supreme Court and how there's 5 important steps in the Supreme Court. The Supreme Court is like no other court in the world. It doesn't operate like, you watch Perry Mason or one of these court shows. It doesn't operate like that. Lawyers have to submit a brief, and then they go before the Supreme Court and actually present oral arguments. There's no testimony as such. There's no, you don't cross-examine witnesses, except the judges can interrupt and cross-examine the lawyers presenting the case. There's also a consideration of what's called amicus curiae, which this is where interested third parties, for instance, I think I mentioned that in the Webster case, there was 78 amicus curiae formed, which was an abortion case. And then the justice will go back and have conference and make a decision, and then they issue an opinion at the last stage. Finally, we discussed the concept of judicial review, and we spent some time on this over the case of Marbury versus Madison, because it is generally considered to be the most important Supreme Court case in American history, because it was in this court case where the Supreme Court assumed the power of constitutional interpretation. That is, they said, we have the right to make a decision if something is constitutional or not. That's not a right given in the Constitution. they assumed that right, and it is an ancient thing in English common law. So it wasn't like it was unique, but we're really not for sure just exactly how extensive the founders really wanted the Supreme Court to use that power. But they used it and have used it ever since. So let's have a little trivia question. What Supreme Court Chief Justice gave his name to the court in the 1950s and 60s, which ushered in a period of judicial activism, resulting in many important court decisions? Okay. Okay. I think a lot of you probably knew this because you were adults when this took place. President Eisenhower appointed Earl Warren, who was the governor of California, in 1953. He really didn't assume the guy was going to be that political. As it turned out, that court, under his Chief Justice stewardship, would usher in a period of what's called judicial activism, which they would issue a lot of rulings that would overturn long held societal, legal, cultural norms that had been at the center of many legal decisions in this country. And kind of was some people call it a constitutional revolution, and since that time, some of these cases have begun to be watered down, as we will see. Okay, so judicial politics. This is what we're going to talk about today to some extent. We had this idea in our heads that the Supreme Court is this big body of 9 men and women that sit up there and kind of like, Moses sitting and giving forth law. And we think that they're neutral. We think that they basically are, unfazed by politics. Folks, nothing could be further from the truth. And this isn't anything new. A lot of people on both sides of the party, right now, the conservatives basically hold the Supreme Court. So the liberals would have you think that the conservatives are so politically involved. And before that, obviously during the Warren Court and some degree the Burger Court, it was the opposite. There has always been politics in the Supreme Court. Now it is true that historically the Supreme Court followed what we call judicial restraint. In other words, they didn't use the Supreme Court a lot to overthrow political opinions. But today, that has begun to be more and more part of the makeup of the Supreme Court. But it's been there from the beginning. There's always been judicial activism. And it can be both liberal or conservative. For instance, in the decades between the founding of this country and the Civil War, the Supreme Court issued many cases that were politically tinged when it came to national supremacy and slavery. And then from the period of Reconstruction up through the Great Depression, beginning of the Great Depression, a lot of issues, societal issues, were dealt with by the Supreme Court, as well as economic issues. This is when the country was growing economically. And again, you look at the progressive era in the early part of the 20th century and last part of the 19th century, you begin to see the Supreme Court becoming more politically oriented. And of course, from 1936 on, a lot of cases in the realm of what we call political liberty. The rights of individuals have been at the forefront of the court. And like I said, it's important to note that judicial activism can be on both sides of the political ideologies. It's neither just used by liberals or conservatives. It's been there on both sides. It all began to change much more radically. This period of judicial restraint began to change under FDR. And it was here that you begin to see, as the cartoon will show you there, that the Supreme Court began to take a much more politically involved part in the running of our government. Now, since FDR, there's basically been 6 chief justices, and we're going to just run through what's called these courts to kind of show you the progression of judicial activism in the court. The first one is called the Stone Court. 1925, Harlan Stone was appointed a associate judge, replacing Charles Eben Hughes. And then he was elevated to Chief Justice in 1941. And when he was elevated to Chief Justice, he and a group of, a majority of the court, justices like Hugo Black, Felix Frankfurter, William O. Douglas, Robert Jackson, those 5 men helped usher in a period of judicial activism. And their belief was they were what were called textualists. They believed that the text is what is important, and you can read it, and that text has to be interpreted as a living document, and that it should be interpreted in view of how society has changed. In other words, they say it's not something written in stone like the Ten Commandments. You have to look at it in terms of how society has changed and how we can interpret the Constitution. Now, not everybody believes in that, as we'll see in a little bit. FDR was also a proponent of what's called judicial pragmatism, and kind of ushered this whole concept of textualism. And when the court surprisingly overturned some of his New Deal reforms, he got very upset about it. And so he decided that he was going to pack the court. And so he made an announcement, much as President Biden did towards the end of his presidency, that he was going to try to get a whole bunch of new seats added to the Supreme Court and pack it with people more akin to his political philosophy. Of course, just like President Biden, FDR was met with widespread, rebuke, because everybody realizes that that's not really a good idea. I won't say everybody, but a great majority of the people in government and probably in society really are a little hesitant about that. We're set at 9 justices now, and I think most of us realize that, it's going to change. Right now, we are in a period of more conservative action on the part of the Supreme Court. That will change eventually. Somewhere along the line, it will become much more active again and what's called the textual point of view. By the way, that was Harlan Stone, who was the head of the Supreme Court during the latter years of FDR, and who began to really usher in this judicial activism. When he died in 1946, right after FDR did, President Harry Truman replaced him with a man by the name of Fred Vinson, who was much more conservative. He was much more back in the realm of judicial restraint. And he served for the next 7 years as the Chief Justice. Probably the reason he was much more restrained as far as issuing decisions, along with the other 4 who made up the majority then, was because he had served in all 3 branches of the government. Very unusual. Most judges are not do not serve in all the branches of government. Now, many of them will serve in one or the other, but most of them are not really have a background in everything. He'd been a U.S. congressman, he had been a justice in the United States Courts of Appeals, and he had been Truman's Secretary of the Treasury before he was appointed the Chief Justice of the Supreme Court. Because he had been a legislator, as had some of the other members of the Supreme Court, they were very cognizant of the fact that they weren't supposed to be making legislation. And so they kind of ushered in a brief era here where they began to go back towards judicial restraint. They didn't overturn a lot of the Harlan Stone's decisions and these other judges, but they did most certainly put some handcuffs on it. As it turned out, 2 of the justices that served under the Vinson Court would later on become the keystones of this judicial activism of the 1950s and 60s. One of them was William O. Douglas, and the other one was Hugo Black. These two were very liberal justices, and they served as kind of the key justices during the next court, which was the Warren Court. A lot of you remember the Warren Court. I know you do. Earl Warren was appointed Chief Justice in 1953 by President Eisenhower. I don't know that Eisenhower really knew what he was getting when he appointed him. He was a Republican. He had been the governor of California. And I think Eisenhower thought that, because of his executive experience, he would be a little bit more judicially restrained. As it turned out, his court over the next 16 years would be the most judicially active court in the history of America. They would usher in what many people have called a constitutional revolution. I mean, they issued so many rulings that overturned the societal, economic, political norms of this country. Now, I'm not saying they were bad. I'm just telling you that they ushered in a whole bunch of new type of decisions that overturned previous concepts of society. Obviously, one of the key was the Brown versus Board of Education at Tobacco, where they mandated school integration. This has probably been long overdue, but they finally issued this in 1954. They also issued in 1966, they kind of went on a rampage in the late 60s, Miranda versus Arizona, which mandated rights to an accused individual. We're going to talk about each one of these in much more detail when we get to the Bill of Rights and the amendments. In 1967, they issued a decision in Loving versus Virginia, which overturned laws banning interracial marriage. It's hard for us to believe at this stage of our life that it wasn't that long ago. I would have been a sophomore in college when it was still illegal in many states for people of different races to marry. State of Virginia. And then in 1972, the Warren Court issued Furman versus Georgia, which ended the death penalty for a period of time. And of course, the biggie was 1973 Roe v. Wade, which mandated abortion as a federally protected right. And this, of course, was a huge decision, which had just, it kind of signaled the, apex of this judicial activism that the court was on. And it really got a lot of people upset. A lot of people felt like it was totally a bad decision, not just because they didn't agree with abortion, because they felt like that's not what the Constitution said. We'll talk about that a little bit later. Okay, we're not going to talk about it today. In 1969, I believe it was, Warren Burger took over the Supreme Court, the Chief Justice. He was appointed by President Nixon. And you begin to see a movement back away from the political activism of the Warren Court. For instance, they issued a ruling in 1976 called the Bakke decision, and it forbid reverse discrimination, where a white man actually sued saying he had been discriminated against because they had quotas and all in hiring or in admission policies in universities. And then they reinstated what was called the good faith doctrine, which gave more leeway to police in searches. As we're going to find out when we get into the Bill of Rights, it was in the 60s that they really began to restrict what police could search. And we're going to get into that quite a bit of detail. U.S. versus Leon indicated a movement away from that, where we begin to water down some of these decisions. They also ruled that the death penalty was not cruel and unusual. Unlike Furman versus Georgia, they said as long as there were certain safeguards met, and today several states still have the death penalty again. Pardon me. And you begin to see, again, a movement towards restrictions of abortion. I'm sorry. I've still got sinus problems from my Michigan winter, okay? So the Burger Court was a movement away from the judicial activism of the 1950s and 60s. And then in 1986, Ronald Reagan appointed William Rehnquist as the Chief Justice. He had been on the Supreme Court for a few years. And when Warren Burger died, he made him the Chief Justice. Rehnquist was a very important follower of what's called originalism, where their belief is that you need to go back and look at the Constitution and interpret the Constitution as was written by the people who wrote it. In other words, what did they mean when they wrote the Constitution? What did it mean when they said that? I can't give you an example right now, but what do they mean in terms of later on things like freedom of speech and all like this? So originalism became the moving factor in the Supreme Court, and you begin to move slowly and gradually away from judicial activism back towards judicial restraint. For instance, they struck down gun-free school districts under U.S. versus Lopez. We all remember very clearly in 2000, the Bush v. Gore, where they involved themselves in the presidential election, which a lot of people felt like they didn't have any business doing. They said, no, we have interpreted the Constitution the way the founders said they expected it to be done. And there's a date certain here in December, and this election has to be called. You cannot wait any longer. And then they begin to water down some of the testimony allowed in criminal cases. They begin to allow hearsay statements. In other words, secondhand statements. They didn't go all the way. For instance, they didn't rule out Roe v. Wade, abortion. They didn't rule out Miranda versus Arizona. And they did rule in homosexual marriage in Lawrence versus Texas, where they said you can't keep homosexuals from marrying. So again, the Rehnquist court began to move away from the Warren court and the judicial activism of the 50s and 60s. Well, today we have what's called the Roberts Court. John Roberts was appointed Chief Justice in 2005 by George W. Bush. And he is basically the head of the court, which has become much more of an originalist Supreme Court. There are now 6 members on the court. One of them was appointed way back by Ronald Reagan, which is Clarence Thomas. And then you have 5 others, which was appointed by George W. Bush and 3 Trump appointees. So these 6 members appointed by the Republicans have comprised what is now the originalist wing of the Supreme Court, and they are basically in charge right now. And again, this is one of the important sidelights that's probably going to come out of the Supreme Court, out of the second Trump presidency, because it's very possible that you might see at least 1, possibly 2 appointees during Trump's second term. I would almost bet that Clarence Thomas is going to retire at some point. And he is probably the most conservative of all the Supreme Court justices. And he will be replaced by a conservative because the Republicans hold the Senate and they hold the presidency. Very well could be that Sonia Sotomayor may retire because she's had some health issues, and a lot of people were begging her to retire in the last year of Biden's presidency, hoping that she would retire so he could appoint someone so that seat would be saved for the judicial active wing, the textualist wing of our country. Didn't work out, okay? So what has the Roberts Court done? Well, folks, they have gone almost radically away from judicial restraint as much as the Warren Court went towards it in the 1950s and 60s. They basically have ruled in D.C. versus Heller that there is a right to gun ownership in this country. They have incorporated it. I know that doesn't make any sense to you right now, but it will when we get into it later. They've also ruled in Citizens United versus the Federal Election Commission that it is not illegal for corporations to contribute money to elections. They ruled that in Burwell versus Hobby Lobby, they ruled that corporations can deny people insurance parts of it that, for instance, they said, we don't want to, the Green family, which owned Hobby Lobby, said, we don't want insurance that pays for contraceptives. We don't believe in contraceptives. And the Supreme Court said, this is illegal. You can do this. You do not have to force, companies cannot be forced to have company insurance that mandates contraceptives. In 2018, Trump issued certain orders restricting travel from some countries when, remember when the terrorists were really going wild here at this point in time. And he said, hey, we're going to restrict travel for some of these countries like Iran and Yemen and the Sudan and some of these countries like this, which are strong supporters of terrorism. And we're not going to let anybody into this country right now from these countries. And the Supreme Court upheld it. And of course, the biggie was Dobbs versus Jackson, where the Supreme Court ruled that indeed the Warren Court had misinterpreted the Supreme Court and that abortion was not a federally protected right. It did not rule that abortion could not be the law of the land, but it said it needs to go back to the states. This is a state issue. And since that time, several states have basically put in their constitution that abortion is legal. Missouri is one of them. Michigan is one of them. They also ruled religious freedom. In Kennedy versus Bremerton in 2022, they ruled that a coach has a right to say prayers with his students on the football field. They fired a coach for doing that, and he sued took it to the Supreme Court, and they ruled no, you can't deny that right. And they also ruled in Creative LLC versus Elenis 2023 that a company cannot be forced to do business with something that they disagree with. In this case, I believe it was a cake store that would not make a cake for a gay wedding. And the people sued saying they had to be forced to make this cake. And the Supreme Court eventually said, no, they don't have to be forced. They don't, they're a private business. If they don't want to make a cake, then they have a right not to make the cake. Okay. We're going to talk about each one of these in quite a bit more detail when we get into the civil rights and civil liberties of the Bill of Rights. So like I said, it's going to be a lot more interesting, I can guarantee you. Well, the last few minutes we're going to spend here is we're going to hopefully briefly look at the next four articles. Article 1 deals with the executive branch. Article 2 deals with the, Article 1 deals with the legislative branch. Article 2 deals with the executive branch. Article 3, we just finished, deals with the federal judiciary. Articles 4, 5, 6, and 7 are kind of cleanup articles. It's not that they're not important. It's just that most of us don't really don't understand what they have to do with us. Let's put it that way. Okay. So Article 4, there are 4 sections which outline the relationships between each state as well as the relationship between each state and the federal government. That's what Article 4 is doing. They're kind of establishing in this article the relationships between states and the federal government. For instance, in Article 1, it's called the Full Faith and Credit Clause, which addresses the duty of each state to respect the public acts, records, and judicial proceedings of every other state. So what does this mean in plain language? Well, this is what it means. If I get a divorce in Missouri and I go to Michigan, that divorce is recognized by the state of Michigan. If I get married in Arkansas and I go to California, California has to recognize that as a legal marriage, even though it may not meet the standards of legal marriage in that state. For instance, there are still states where you can get married at a very young age. Uh, Actually, Missouri is one of them. And a lot of states have made it where you have to be much older to get married. It doesn't matter if you don't meet the standards of that state. As long as you were married in a state legally and you move to another state, they have to recognize that marriage. Uh, by the way, this became the center of dispute in 1996 when Congress passed what was called the Defense of Marriage Act, uh, where they ruled that marriage was between one man and one woman. And they allowed states to refuse same sex marriages. Of course, ultimately, the Supreme Court overruled that in 2013. And then they went even further in Texas versus Lawrence. And they basically said, you can't do that. You know, you have a right, yeah, people have a right for their marriage to be recognized. As long as it's a legal marriage in one state, it's a legal marriage in every state. That's what full faith and credit means. There's also a clause in Article 4, Section 2, called the Privileges and Immunities Clause. What does this mean? Well, it means that basically it grants to all citizens of every state the right to be treated equally as the citizens of that state. So, example, okay? Let's say that you go from Missouri to Colorado and you want to go hunting. Colorado cannot keep you from getting a hunting license. Now, they can charge you more as an out of state hunter or an out of state fisherman, but they cannot keep you from hunting in that state as long as you meet all the legal requirements of hunting. You know, I mean, if you're a felon or an ex-felon, you can't hold a firearm. So, maybe at that point in time, they could restrict it. But let's say I have a fishing license in Missouri and I go to Colorado and I apply for an out-of-state fishing license. They can't keep me from getting an out-of-state fishing license. They can charge me more, but they can't keep me from getting an out-of-state fishing license. There's also the extradition of fugitives clause. What this basically says is that fugitives in justice may be extradited upon demand from a state from which they fled. In other words, if I commit a crime in the state of Michigan and I flee back to my home state of Missouri, and Michigan finds out I'm back there and they want me, they can ask for extradition. And unless there's a real good reason, the state of Missouri has to extradite me back to Michigan. By the way, interesting enough, the Supreme Court has ruled that it doesn't necessarily mean the government has to extradite you. This is where the bounty hunters come in. Okay. If I'm a bounty hunter and I find out that this guy is in Missouri and he's wanted in Michigan, and there's a bounty, he's abandoned bail, and basically the guy that's got his bail says, "Hey, Bond, you go get him, and I'll pay you X number of dollars to get him back here." You can go to another state and forcefully take him without a warrant and bring him back to the state. I know that sounds weird, but that's the bounty hunter type thing. There is a third part of Article 4, which is no longer in effect, called the Fugitive Slave Clause. And this was rendered moot by the 13th Amendment, where originally slaves could be extradited upon the claims of their masters. Obviously, this no longer can happen because we don't have slavery in this country. So that it's still in the Constitution, but it's been ruled moot because of the 13th Amendment. Okay, Article 4 also has a technical clause in there, our Section 3, which tells how new states can be added to the Union. What it basically says is this: every state has to be added to the Union on equal terms. You cannot make requirements more for one state than you did for another state. It also forbids carving new states out of existing ones without the consent of the affected states. This occurred earlier in Maine and in West Virginia, where these states were carved out. Maine was carved out of Massachusetts, and West Virginia was carved out of Virginia without the consent of the home state. And they ruled later on, no, you can't do that. You know, uh, so they can't do it. By the way, this is really interesting, and I didn't know this till I began to study this. Uh, we often hear about states that wanting to secede, and of course we saw this in the Civil War. Uh, for instance, I'm going back to my old home state here. In the very southwest corner of Missouri, there's a county called McDonald County. If you know anything about McDonald County, you probably know that it is extremely conservative. I mean, extremely conservative. And they were so upset back in the late 50s, early 60s with the way the national government was going that they seceded from the Union. Now, it was kind of a put on affair, but I remember it made national news. And here's a picture of a bunch of guys on a truck carrying the McDonald Territory Border Patrol. And they basically said, we have seceded from the Union and you can't keep us from doing it. They issued visas. They issued, I mean, it wasn't a joke, but it was done kind of to get national attention. And, of course, it's totally illegal. They couldn't do it. But, what I didn't realize is that states there's a question about this, may be able to secede as long as the other states or Congress gives it the right to do so. So let's just go down a rabbit hole here. Let's say that California decides that they no longer want to be a part of the United States. And they say, we would like to secede from the United States and be our own country. It is conceivable. I'm not saying that because it would go to the Supreme Court for interpretation, but it is conceivable that if Congress and or a majority of the other states accepted this, they might be able to do this. There's a possibility that this actually might happen someday. I don't think it will, and I'm not even for sure the Supreme Court would rule on that behalf. But a lot of people think, since the Constitution is silent on it, that it is a possibility, depending upon the makeup of the court, that they might actually give a state permission to leave the Union. Without a doubt, the state that would have the most argument about this would be the state of Texas, because Texas was a country an independent country before they entered into the United States. And so they might say, we wish to go back to our original status, which was an independent country. And it could be that the Supreme Court might actually rule that this could happen. I don't know, but it's interesting, okay? There's also a property clause, which grants Congress the right to manage, control all territories. So that's why we can rule national parks, Indian reservations, military bases, federal buildings, etc. And finally, Article 4 refers to the guarantee clause, which basically says that the United States has to guarantee that Republican principles are given in each one of the states, which is really kind of weird because nowhere in the Constitution does it say the United States government has to do that. But the government of the United States has to make sure that before a state becomes a state, that a Republican form of government has to exist. It's really kind of a strange thing, and a lot of people don't really understand exactly what this means. And then there's the protection clause. This is one of these clauses that are really in the news right now. The protection clause requires the U.S. to protect each state from invasion and from domestic violence upon application of the state legislatures. Now, this has been done many times, particularly when it comes to domestic violence, where the United States government, the president normally will, basically order the military to go in and, protect individuals or state. Remember 1957, when the 101st Airborne, I believe, was ordered into Little Rock, Arkansas, to protect the Little Rock Seven. These students who, basically the governor at that time said there's no way that they're ever going to go to school with white boys and girls. And he basically told 104th Airborne to go in and accompany them in, and they did. What's going on right now is, if you're up with the news, that President Trump has ordered up, I believe it's now up around 11,000 military deployment to the border to help secure the southern border. And of course, I've been listening to the news and people are screaming, saying that's illegal. You can't do it. It's unconstitutional. There's no way the military can be used to do this. Yes, there is, folks. The Article 4 of the Constitution specifically says that if you are under invasion, and who determines you're under invasion? The President of the United States is military commander of the military. And he has issued an executive order to that effect. And he said, because we are under invasion on the southern border, I am issuing an executive order that the military will be deployed to assist in closing the border. It's been done before. It's nothing unusual. It's just that people don't like it right now. Okay, or some people. Okay, Article 5. Article 5 describes the procedures for altering the Constitution. We've kind of discussed this already. By the way, folks, there's 33 amendments to the Constitution have been approved by Congress. 27 have been ratified. That means there's 6 of the 33 that have not been ratified. Now, 4 of those are still technically open. 2 of them failed because they was a sunset clause, and the Supreme Court has upheld this. One of those was the Equal Rights Amendment, which on his last days in office, President Biden basically told the country that was the law of the land, and issued an order that people had to follow the ERA. And people had to remind him, no, sir, they don't, because the Congress, when they issued this, put a sunset clause on it. And the sunset clause had been out of existence for like 30, 40 years. In other words, it didn't get the required number of states to approve it at the time. And since it has expired, then they have to start all over. Article 5 basically shields the subject of certain constitutional clauses from being amended. So it also says originally that Congress could not pass a law restricting the importation of slaves prior to 1808. Obviously, that date's long gone. And then there was also a second prohibition, which provides that no member shall deprive a state of its equal representation. That is still in effect. Congress cannot pass an amendment basically taking away senatorial representation from a state. They cannot do that. Article 5, there are 2 methods for proposing and ratifying an amendment. Okay. The first way you can propose an amendment is for 2/3 of both houses shall deem it necessary. So if 2/3 of the House of Representatives propose an amendment and pass it, then the House of Representatives and the Senate, then it can be put forth for a vote. Or if 2/3 of the state legislatures call a convention for proposing amendments, it can also be proposed that way. Now, you have to be understanding, every amendment proposed has come from Congress, every one of them. There's of the 33 that have been officially proposed, every one of them came from 2/3 of the vote of both houses of Congress. There has never been a national convention called to amend the Constitution. And the reason is very simple. Remember the last time a certain number of states proposed a national convention to amend the Constitution. What happened? They went to Philadelphia in 1787, and in the summer of 1787 wrote a whole brand new government. The Articles of Confederation were thrown out, and we got the Constitution. Good deal, but nobody wants that to happen again. Well, I won't say nobody, but most people don't want it to happen again. They say there's no way that we can do this, because once you have a constitutional convention open to amend the Constitution, there is no telling what might happen. They might write a whole brand new government, and completely do away with the Constitution. Now, that would have to be approved, but you just never know in this day and age. Nobody wants to take that chance. After amendment is officially proposed, Congress is authorized to choose between two methods for ratification. The first method involves Congress sending proposed amendment to the state legislatures. And this method has been used for all 33 proposed amendments except for prohibition, the ending of prohibition, because they said the reason we got prohibition because people said they wanted it. So if you don't want it anymore, then you people tell us. And they did. The second method provides that Congress can send the proposed amendments to state ratifying conventions. This is the one where the 21st Amendment overruled the 18th Amendment. Okay, real quick, and I know I'm running a little bit late here. Article 6, basically there's 3 clauses in there. One of them says that all debts contracted prior to the adoption of the Constitution remain valid. In other words, if the country owed debts under the Articles of Confederation, they had to be assumed by the new government. There is the Supremacy Clause, which provides the Constitution and federal laws pursuant are the supreme law of the land. This was upheld in McCulloch versus Maryland that we've talked about. And then the third clause basically requires all federal and state legislatures, executive officers, judges to swear an oath to support the Constitution. There have been 2 exceptions to this. Number one, in 1866, the President of the United States pardoned most of the senior Confederate officers of the Supreme Court. Well, some of the northern states didn't like this. And when they tried to run for office, they said, you can't run for office because you've been a traitor. And the Supreme Court said, no, they were pardoned for this. There's also been a case where a state tried to require a religious oath. In other words, basically saying you cannot hold office unless you believe in God. And they said you can't do that either. Article 7, the last article, real fast. Article 7 sets the number of state ratifications necessary for the Constitution, and it sets all the methods and all. And originally, only 9 had to approve it in 13 states. Eventually, all 13 did approve it. But for the most part, only 9 had to approve it. Okay, kind of rush through that latter part, but I want to get through with it because next week I want to start on the Bill of Rights. And we're going to take each one of the first 10 amendments and we're going to go into quite a bit of detail. First Amendment basically establishes the civil liberties of religious freedom, freedom of the press, freedom of speech, freedom of assembly. And we're going to talk about this and what the courts have said constitute freedom of religion and freedom of speech. It gets pretty interesting, folks, because some of the things the court has said kind of makes you wonder exactly what they were thinking. So anyway, that's it for the day. I'm sorry I ran just a little bit long. Didn't mean to, but I wanted to get through this part of it. So I hope you've enjoyed this. I hope you found it interesting. And next week, we'll begin the third part of American Scripture, the Bill of Rights and the Amendments. And it'll take us just a couple of months to get through that. And then we're going to start something hopefully totally new and different, which I think you might find interesting. So thank you for being with me today. I hope you've enjoyed it. And tune in next week, Monday, at the same time, same station,